fashioning your own solution to your dispute or problem and being bound by it as though it were a judgment of the court. That is the end result of ADR, Alternative Dispute Resolution. And we are continuing with our discussion. ADR, Cheap and Effective Dispute Resolution. And this is part 2. My guests are with me. Let's first go to the Law 101. I'm Samson Lardy Anyenini.
Act 798, Rules of Customary Arbitration, Section 93, Subsection 1. A customary arbitrator shall apply the rules of natural justice and fairness, and is not obliged to apply any legal rules of procedure in the arbitration.
You are on the law. This is your legal light. It is your help law. And my guest, Martin Nwosu, is legal and ADR practitioner. He's with Regent Law Firm here in Accra, and he's senior lecturer, Ghana School of Law. Alex Nete, National ADR Coordinator, Judicial Service of Ghana, joins us shortly. So we will begin with the Law 101, and today we are looking at the Alternative Dispute Resolution Act 2010, Act 798. We are looking at Rules of Customary Arbitration, Section 93, Subsection 1, which was read to you just a while ago. It says, a customary arbitrator shall apply the rules of natural justice and fairness, and is not obliged to apply any legal rules of procedure in the arbitration. So, first, a recap as to what you defined as customary arbitration to us, and that's the simplest, the cheapest form, the easiest form to find, arbitration. And then explain to us what is meant by Section 93.1.
Thank you once again, Samson, for the opportunity. As rightly stated, when you talk about the rules of natural justice, fairness, what that simply means is that natural justice implies that you must give the two parties equal opportunity to express themselves. Also, you must hear them equally before you render any decision. And invariably, this is quite natural because everybody who has a matter would want to be heard. So it will not be fair on the side of either party for only one to be heard and the other not heard. So in customary arbitration, this is very, very important, that the customary arbitrator should endeavor, ask all the necessary questions, tease out the relevant issues from the parties, interrogate them, and let the two parties contribute as effectively as possible to the issues involved. This way, it could be said to have been fair to the parties. And it's interesting that it says it's not obliged to apply any legal rules, right? Because, in fact, most of the time, the law many people will tell you, is what the ordinary man at KJTR or Makola thinks. It's as simple as that. So the rules become necessary when the thing is escalated to the court forum, for instance, where it is their duty to apply the necessary rules, precedents, and so on and so forth. But when you are dealing with matters at the basic rudimentary level, all you want is for the parties to be fully heard. Then you can tell them that on the basis of their own statement, you see, you didn't do well. You should have done A, B, C, D. But the important and interesting thing about customary arbitration is that the customary arbitrator is like in the position of the judge. Unlike the mediator who leaves the matters for the decision of the parties. In customary arbitration, the arbitrator actually decides for the parties. And to do that fairly, he has to hear them equally.
Right. So let's hear from Alex. What does this mean? We hear often the rules of natural justice, and the lawyers will tell us that it has two legs, and that is that first, you don't condemn a person without hearing them, giving them a hearing, and second, that you should not be a judge in your own matter, in your own case, or what you say, in your own cause. But often, when you are dealing with people who deal with ADR, they would emphasize question of fairness, as he just said. What does Section 93 of the ADR Act, subsection 1 mean?
Thank you very much. Last week when Martin spoke about ADR mechanisms, he did mention customary arbitration.
Right.
And what this provision is trying to point out is that ADR under every circumstance is informal in nature. So ADR is a creation that enables disputing parties and their assistants, people who assist them, such as customary arbitrators and mediators, to create their own environment congenial to facilitate a resolution of the matter. What this also implies is that ADR practice observes some ethical, requirements. And so a customary arbitrator cannot sit on his own case. He cannot be a judge in his own cause. He is also duty bound to create a level playing ground for the parties. The parties must be given equal opportunity. Everybody must be heard. Even if there is need for caucusing, the caucusing must be heard in a manner that demonstrates that you are fair to them. You don't meet one for 2 hours and meet one at 2 minutes. That will raise questions as to which of the parties you place importance upon and all that. And so fairness is the rule. Fairness, equity. See, you cannot say that because he's crying, he's a woman, he's poor, and so even if he's not entitled to 10, he should take 10. You make sure that what each one of the parties deserve is what they get. And before that is done, a dialogue that engender understanding and empathy is undertaken. You engage them fruitfully, you help them with various questions as ADR practice requires to really answer questions that open up the issues. And so sometimes in the process, through this effort to achieve fair play and fairness, you realize that the parties get to instances where they ask, oh, really? Is that the case? In the course of the dialogue, there are principles such as conciliatory gestures that we detect along the line, which are explored to help the parties to attain fairness. So fairness, equity, fairness, fair play, and everybody must get what really is due.
You're right. And last week you explained customary arbitration as is captured in the interpretation section of the law as voluntary submission of a dispute, whether or not relating to a written agreement for a final binding determination. And you explained that it is just a decision of the two parties, or it could be one of them, looking for somebody that they have some respect for and asking the person to resolve, sort of mediate and resolve their issue for them. And then the other party may be also invited once they, agree to the invitation and attend the process, they are able to resolve their issues. So this section now brings to the fore the need for the one who is in control of the process, so to speak, to allow fairness to rule. Thank you very much.
Yes.
Now, yes.
So, particularly when it comes to customary law, customs vary from a community to a community.
Right.
And so, if the parties are from the same community and they have the same personal law, one of the rules of the customary arbitrator is to help these parties before him to understand what the custom regarding the situation is. So, if the custom requires that an offense is resolved with an offer of 2 bottles of schnapps, you don't take 3 from him because he's illiterate or he comes from the royal family.
Okay.
You make sure that that principle, which has been practiced and recognized within that community, is applied.
All right. All right. Thank you very much. And if you remember also, and you don't have to forget that, because last week we began on this note with the Law 101 on sections 82 and 52. Section 82 is to the effect that where the parties agree that a settlement is binding, the settlement agreement has the same effect as if it is an arbitral award under section 52. And section 52 says that subject to the right of a party to set aside an award under section 58 of this act, an arbitration award is final and binding as between the parties and any person claiming through or under them. The binding nature or effect of the ADR process once you go through it. So now, let's, since we have started on rules that are supposed to be observed under ADR, let's get to know some more of the rules that are supposed to be observed in the process by the mediators and the arbitrators. Yes.
Yes, so when it comes to the mediators, for instance, the rule of thumb is that after the parties have applied to have their matter resolved through mediation, the mediator would invite them, he would welcome them very congenially, and then set what we call the ground rules as part of the opening statement. Now, how do you want us to proceed with this discussion? For instance, should we put our phones off, or should we mute them so we can follow our missed calls after the discussion, and all that? Okay. Alex mentioned caucusing, and it's a very important component in mediation. What happens in caucusing is that, depending on how the conversation is unfolding, the mediator could sometimes not get the head or tail of what is happening, and may say to himself that if this was all there is to the discussion, I don't think there should have been any dispute. It means one of the parties is not feeling very comfortable to make certain disclosure at that plenary session. So very shrewdly, the mediator would have told them in advance that depending on how the discussion is unfolding, there's a process called caucusing. We will resort to it. And what it means is that I may have to talk to one of you privately. Doing that doesn't mean I'm siding with that person. And that was the caution Alex was mentioning.
Right.
And then if it is necessary after seeing this person in private, I may also see you in private. But meanwhile, while we are gone in private to have this discussion, to extend what we are discussing, please be thinking about how you would want this matter resolved. So you give me a kind of assignment to engage his attention.
Okay.
So that is caucusing, and you have to say it in advance. This is very, very critical, because if you don't, and you begin to realize that there is the need for caucusing, and you now want to pull it off the cuff, the parties will say, oh, I mean, what is happening here? Especially if it's a dispute between a husband and a wife, and you want to see the wife in caucusing. There have been instances where the man simply said, look, is that why you brought me here? If you're interested in her, I'm going, you can have her. That kind of thing. So some of these rules must be observed. And you also let them know that mediation is a very voluntary process. If at any point in time you are not comfortable with the way it is going, you are at liberty to leave.
Okay.
People have thought that when you give them that kind of leverage, they can just walk away. But by telling them that, you are rather empowering them.
All right.
To enable them understand that this is our game. We play it the way we want to our mutual satisfaction.
So you are talking about what you say is the ground rules
It's the ground
that the mediator must tell the parties
exactly, before he
ahead of
starts.
time. Okay.
And it's a kind of education they need, because as we indicated, the game is actually between the parties. As we mentioned last week, mediation is actually facilitated or assisted negotiation.
Right.
Ideally, it is the two parties who are going to engage. So they have to understand that rule of engagement, what they should say when and how, and so on and so forth. That is why in mediation, the opening statement, part of which is what we are discussing, is very, very critical.
Right.
If you don't perform the opening statement in a mediation process, you can be sure to fail, because that is what lays the foundation. So as part of the rules, this has to be observed before you kickstart it. And interestingly, sometimes even that's the way you welcome the parties. You see, you should find very interesting comments. They are coming agitated, they don't know what to expect. Some of them are really worried. So you should find a way to break the ice from the word go. Sometimes, probably depending on how they are dressed, you might see something similar. Hey, are we dealing with a twin situation here today? They'll look at each other and, oh, the way you are, I just realized that you are wearing the same earrings. So you have to be very, very observant. Your whole mindset is to say things that will calm down the parties' nerves, so that they will know that, yes, this gentleman is really here for us, to help us find a solution to this problem.
Right. Alex, what would you like to add regarding the rules that are supposed to be observed in the process?
Yes. As you seek to empower the parties and to make the process relevant and promising, you need to ensure that the parties choose the language they want to engage in.
All right.
Yes. So you don't say that this is court-connected ADR and the medium of engagement is English and that is all that we have. It is open. And it is the duty of the ADR process managers to ensure that all resources required to complement the parties to operate the way they prefer are provided. Again, timing the hour of engagement. We say ADR is formal. So you don't say that the mediator has a diary which overrides that of the parties.
ADR is informal or formal?
It's informal.
Okay.
It's informal. Did I say formal?
Yes, please.
Yes. It is informal. And therefore, it is the parties that are being served and not the mediator or those who are facilitating it who are being served. So just as it is said in the court, oh my Lord, subject to your overriding convenience, it is the parties before the ADR whose convenience is very, very critical. So you don't even restrict the parties to a particular hour. You engage them, let them agree on a time that they are comfortable with. These are some of the things that mediators need to observe to ensure that the parties are motivated to stay put and open up for the process.
Right. Now, Martin, is it not difficult to achieve that we are sort of at loggerheads? We are disputing, we have our differences. Is it not difficult for us, first of all, to agree to bring our issue to Martin to resolve for us? So if I am the one who feel that you are in a position to help us resolve our issue because you're an ADR practitioner, or there's an ADR, institution or center somewhere, or as when it happens in the situation that Alex coordinates in the court, a judge, you agree with the judge that this matter can go for ADR, and then one is agreeing, one is not agreeing. How do you resolve that situation?
Well, in ADR, it's always voluntary. You can't compel the parties. A judge may well refer the parties to ADR in a court-connected process. When they get to the mediator, they can tell him, as for me, I'm not interested, though. It's the judge who said we should come, but me, I want the court to resolve the matter. That's the end of it.
That's it?
Yes, you can't compel him.
You can't try to convince or persuade.
You may try to say, look, the judge wants you to come and try this, looking at the nature of the case. The judge has observed that the person you have this dispute is your very good friend or is a business partner. You have certain things in common. So he doesn't want that relationship to be destroyed. That is why he has referred the matter to ADR. So please think about it carefully. We can't really force you, but you can go think through it. If tomorrow you think you can come, we'll be ready for you, that kind of situation. But you don't ever compel the parties to negotiate in a mediation process. Additionally, if it is a private process too, that is why the rules of engagement are very important. See, you can't force them, you are there for them. But there are very innocuous means of ascertaining the facts and gradually allowing the parties to begin to talk to each other. So we have what we call the phases of mediation. Now, the first phase of mediation is what we indicated when they are welcome, ground rules, all those things are discussed. Then the second phase is discussing what has brought them there. Okay. Well, and then you let them know that, normally the person who reported the matter, like in the court, the plaintiff will be allowed to speak first, but there are no hard and fast rule. If the defendant wants to speak first and the plaintiff allows it, fine. But the important thing to a mediation process is for the parties to talk. And now the mediator can ask, okay, so can you explain to me why you brought this matter here? He's invited one of the parties to explain to him. In many situations, the two parties are even at loggerheads. They are not talking to each other. But by inviting him to talk to the mediator, the other party is sitting there.
That's right.
Now, as you are talking to the mediator, that other party is also listening.
That's
he
right.
might be looking away as if he's not interested, but he's listening. Now, Samson, the magic of this is, as the first party is explaining to the mediator, and this other person listening, he begins to gather certain perspectives and understanding that in his wildest imagination he thought was impossible. Oh, so when he did A, B, C, D, this was actually what he meant. Like we used the iPad last week.
Right.
So when he was grabbing the thing, he wasn't taking it away from me and running. He wasn't trying to steal it. He actually has something, a reference to make. Oh, now if I had known, what is that? I could have given it to him. So you talk to me.
Right.
Now, he's listening. After that, it reverses. Okay, you've heard your friend. Thank you for explaining the situation. So, Mr. Nati, can you also explain to us why you are here? The same process goes on. You would also be listening. So at the end of the day, you move to the next stage. Now they have spoken to you. After you, first of all, you speak to them.
Right.
You spoke to them initially. Second stage, they spoke to you. Now you want to get them to talk to each other. Now after listening to you, this is what you are saying. You wanted the iPad for a quick reference. Now, Mr. Nati, did you understand that that was what he wanted? No, he didn't speak to me. He just came and grabbed it. Okay, so can you now explain to him why you wanted it? Oh, it's just for a quick reference. Now, the parties who weren't initially talking to each other are gradually now beginning to talk to each other.
This is the law. It's your legal light. It's your help law. And our guests from last week are back here today. Alex Nete is National ADR Coordinator, Judicial Service of Ghana. Martin Nwosu is legal and ADR practitioner. He's a senior lecturer at the Ghana School of Law. And as we promised you last week, because we couldn't actually spend time on your questions and comments, this afternoon we are opening the lines right about now so that you can join. Just give us some 5 minutes and then we'll come to you. Look at the screen and you see the telephone numbers to call, and then you call in and let's hear you. Say in a customary arbitration, I have two questions in one. I decide that, this elder in my church is somebody I know that you also have respect for. And since we can't resolve our matter, I want to go to him to try and sit us down to settle the matter. Or this chief in our village, we are all there together, is a chief that we all have respect for. Let's go see this chief, talk to him. So I go there and talk to the chief. So this elder or chief invites the other party. If the other party doesn't go, it doesn't work. That's it, end of it.
If the other party doesn't go, it doesn't work. Because in customary arbitration, the consent of the other party is also critical. The principles of natural justice prevails there. And so the person must necessarily respond, go and say that, yes, I know him, we have an issue, and yes, I am ready. If Nana, Uncle, Abusia Penny, you are ready to help us, when can we come? We have, in our modern times, some instances where the critical customary consents are not demanded. But in a typical customary setting, then of course, before you file your action before him, you must present a drink. And by way of consent, you must also offer something to show that indeed they have offered consent. He has filed an appearance.
You spoke about rules of natural justice and the rest of them. Supposing that I don't want to show disrespect to my chief, but I have suspicion that he has some interest in the matter.
Yes.
What should I do?
Yes. Those who are courageous can tell whoever is inviting the parties to appear before him that, and I'm sorry, I'll prefer that this case rather goes to court.
Or someone else.
Or someone else. And I don't want you to handle this matter. And so we cannot come to you, or I cannot respond to your invitation for this sitting. Others will come, they say the following day, because he did not offer a consent customarily, he will not come. And that means that he has declined to participate in the process. Okay.
The other part of what I was seeking, Martin, is this, that you are talking about rules, and these rules are in the law. This law was passed only in 2010. Before then, you had referred last week to other, legislation that helped the process. How is the person who is not an ADR practitioner supposed to know these rules and stick by them in seeking to resolve, a dispute that has been brought to them?
Now, this is where the role of civil society becomes very important. We have an association called the Ghana Association of Certified Mediators and Arbitrators, which engages in training of members of civil society, religious groups, queen mothers, chiefs, and so on and so forth, and other such organizations. So it is our mandate to penetrate some of these enclaves and train them that this is actually available and get to know it so you can utilize it. Now, it's even more critical because the rules of customary arbitration as provided in the law is slightly different from what our customary authority bearers were doing previously. You know, at that time, Alex talks about consent. Those days, if the chief calls you, who born dog, you have to go. He brings his staff, Nana wants you at the palace, you will go, whether you like it or not. And when you go there, he starts talking. Sometimes they don't even want to know, especially if it's a husband-wife relationship.
We'll come to you shortly, Evelyn. Evelyn is calling us from Dansoman. Yes.
You see, so some of these things, now in the customary arbitration part of the ADR Act, everything had been clarified. What you can do, how you can do it, how you should do it, and what you cannot do.
Right. So we'll come to answer the question, what is it that if the arbitrator or the parties do not do in the process, or the mediator do not do in the process, will, as it were, invalidate what you have done? And then, let's remember last week we ended on the note on what issues are amenable to ADR and what issues cannot be submitted for ADR. Good afternoon, Evelyn. Thank you for joining us from Dansoman. Let's hear you.
Good afternoon, Samson.
Hi.
I want to make a little contribution.
All right.
You know, in mediation, I learned that if you not be objective enough, there's something we call an exit card. Even before you even meet the party, it could be that you know party A or you know party B. And as a result of that, you not be objective enough, you just exit for fairness.
Okay. What we do in court, we call recusal. Recuse yourself.
Okay.
Right.
Okay. Now, where I work, we use the exit card.
All right.
All right.
But is it also possible from where you work that you can make a certain disclosure and ask the party that is not comfortable with you whether or not they are okay with you?
Exactly.
That is also allowed.
Yes, please.
Okay. Thank you, Evelyn. Evelyn called us from Dansoman.
Thank you.
What will you say about what she just spoke about?
Yes, that is precisely what is done. And it also fulfills some of the ethical and the principles of natural justice. Yes. So you do a full disclosure. If you know that you have a certain relationship with one of the parties, you disclose it. As if it is said that no matter what you do, it will still raise a question as to your neutrality. Then you clearly recuse yourself. Tell them that, look, I cannot, because of my relationship with ABC, I cannot be a mediator. And
the relationship could be what? Business relationship?
Business relationship.
Maybe you are in church together, you sit on a board together.
You belong to the same old school association.
Okay.
You work in the same place. You are a door.
Could be family.
Yes, you could be a neighbor in the same community, family, or
and that relationship predisposes you to be biased.
If it does not directly, you still have to disclose it.
Okay.
So that everybody could be sure of the integrity of the process.
Apia, you're calling us from Ahafo. Hello, Apia, let's hear you. Hello, Apia.
How does one become ADR expert?
How does one become an ADR expert?
ADR expert.
Okay.
By the way, you are looking very good.
Thank you, Apia. Okay, so Martin, you can help with that.
It's all training. If you are interested in ADR, you would observe that every now and again, training programs are advertised in the paper, on social media, so you can apply. I just mentioned one organization. There are other such organizations that offer training. And so, Apia, just be on the lookout, and you will find places you can train to become a mediator.
Okay. There are those who go through a formal sort of environment to become, ADR practitioners. Can you shed light on that so that...
Well, if you want to go through the school, now there are courses you can pursue.
Right.
Academic programs you can pursue, even up to the master's level.
That's right.
PhD level.
Even now up to PhD, right here in Ghana, at some of our law schools. So if you, the academic type, and you want to go that route, it's possible. But what I just talked about is the practical. The person want to become a practicing mediator or customary arbitrator for that matter.
Okay.
You can go for some of this training and as quickly
How
as
long?
possible.
How long does it take?
You don't need to start with a very long, training process.
Okay.
The basic training requirement is 40 hours. If you obtain a well-organized 40-hour training, you can do your basic mediation and negotiation exercises. Then as you practice, you open yourself to opportunities.
Okay.
Yes.
All right. And there are associations or there are institutions
That's right.
that people become associates of. They become chartered, and so on and so forth. In the UK and elsewhere, more importantly. Muntari, you're calling us from Tamale. After you, we'll hear from Mark, who is calling from Nsawam. Hello.
Yes, Samson, good afternoon.
Good afternoon. Let's hear you.
Yes, I would like to find out if ADR applies to all cases. For instance, we have criminal cases where there is a rape case or there is a defilement case, and the chief says, you bring the case to me, withdraw the case from the police, let me handle that. The law permits that.
Okay, so we just hinted that we're going to that part of it. What cases are amenable and what cases are not? So we'll get your answers. Mark, you're calling from Nsawam.
Yeah. Okay. Yeah, my name is Mark. Hello.
Go ahead.
Yeah. Please, I'm calling from Nsawam. My name is Mark. Please, if I am a defendant in a case, can I request that my case be sent to ADR, and can the plaintiff be opposed to it? All
right. Thank you very much, Mark. So clearly, Mark's question is for you. You are in charge of coordinating ADR in the courts. Yes.
Yes, Mark. The answer is yes, because ADR has become a core component of our adjudication system. It is open to all of us in the court to find out as to how we assess it. And so either the mediator or the plaintiff or the defendant can find out from the judge if the case is amenable to ADR. And if it's amenable, the judge will find out from the plaintiff whether or not he agrees. In fact, the consent of the other party must always be solicited and gotten to enable the process to take off properly. And you recall that last week we said that when you go to court and you are asking for ADR, don't have the temptation to feel that perhaps somebody will say that you are not sure of yourself, you are afraid you will be defeated or you will lose. That is why you are asking for ADR. In fact, anybody who opts for ADR is clearly demonstrating that he has many other things to do and that he's not on there to litigate all his life. He believes in time, he knows how to save money on litigation through ADR, stress, and what have you. And again, before any dispute, litigation, there is always a relationship, a fruitful relationship.
Right.
And so people are guided by what may have been their relationship, how each other may have helped in this life before the litigation came up.
Okay.
And so these are the factors that people who opt for ADR consider.
We will not forget Muntari's questioning, which is what cases are amenable to ADR. But William is calling from Cape Coast. I don't want us to keep him on the phone. And also remember that even in the court, when it comes to commercial matters, ADR is a first compulsory process. So don't be afraid, don't be shy about it. It's first compulsory. All the parties must submit to it before, if it fails, then the case will go to a judge to hear it. Hello, William, let's hear you. Yes, go ahead, William.
I've been to ADR before on 2 occasions. One, I was part of the party, and the other one, I was to accompany one of the parties to the point, the ADR settlement office. So I'm talking about the second one. What I realized was that the coordinators or the officers at the ADR, they were very hostile to the party.
Really?
Yes.
Is this ADR from the court or these are private people?
ADR from the court, and I don't want to mention the court. People will zero in to know the people.
And the mediators were hostile?
Yes, this is what I mean by very hostile. Hey, sit here, do this. You don't give us money. And then this, Mr. Osimesi, this is ADR, and it is backed by law and some regulations. And the way you are treating these people, I'm surprised you are doing this. They wouldn't be able to disclose what is there for you to settle the issue. Like I was predicting, it came to pass. It never worked. They move out. In my case, that was a personal one. I went there, and the two of us, the parties, we couldn't agree. So that very day, we had to push it back to what they call it, the normal court, and then the following day, a party, I wouldn't say me or the other one, a party raised their hand and said, yes, I've accepted everything, let's go ahead this way. And then they said the consent judgment or what, yes, those things were done.
Okay.
But the other one I witnessed, I didn't like it at all.
Thank you very much. Thank you very much, William. And we'll come for you to address William's, because the first principles that ADR practitioners learn is not to do what you say ADR officers are allegedly doing. Yes, now to Muntari. Which matters are amenable to ADR and which matters are not? He asked a question about a chief saying that this is a criminal matter, and the chief saying, bring it to me, let me resolve it, go and remove it from the court.
Well, that is clearly wrong, because criminal matters generally are not amenable to ADR. And the law has also itemized other matters, environmental issues, matters involving the Constitution interpretation. They don't go there. Or matters that, again, the law says are of public interest.
Right.
Now, we don't go there. But classically, criminal matters in general, especially serious crime, what we call the felonies, first degree, second degree felonies, are not amenable to ADR. But in the wisdom of the framers of the law, there is an aspect of criminal matters that are not escalated, what we call misdemeanors or minor crimes, that can be entertained under ADR, under a special heading we call victim offender mediation process. Now, what happens is that even though it may come up as a criminal offense, if you interrogate it very critically, you realize that the ingredients of what lawyers call the ingredients of a crime, the actus reus, and then the menstruia, they might not be there. In the flip of a moment, a person is annoyed in the household or compound house setting, or even among friends, or even between husband and wife, and somebody throws their hand. He hadn't formulated that mind of committing that kind of atrocity, but it just happened.
Okay.
So those kind of situations can be entertained under Section 73 of the Courts Act, and it's interesting because the Courts Act predates the ADR that we are talking about,
right.
But it has long been observed that certain criminal activities are not serious crimes.
Right.
So we should rather help the parties to settle their differences. So
and that's what the Courts Act talks about, promotion of reconciliation.
Exactly.
Right. So if it is not aggravated in degree, like you have said, misdemeanors, the court, in fact, if it shows up in court, the judge will actually tell you that try and settle it.
Yeah.
Okay.
Samson, for instance, stealing is one of the cases that do not go for mediation.
Okay.
But there was a situation. A door neighbor's son entered the neighbor's room and picked money, take about 7,000, a student. And he went to the police. all attempts to get the case resolved in view of the circumstances that it occurred did not work at that level. When you go to the court, the judge said, yes, this can be referred to as stealing. But looking at the environment in which this thing took place, I will encourage reconciliation. And indeed, they were able to resolve it. So we say that it is judge-led. Judges are there to help us actually do justice. Then, when it is also a civil case, but there is fraud pleaded in it, the law says you can't go for ADR. So these are some of the things.
Okay, let me pick Ishan and Kojo. Then I will return to my guest again, because in fact some of the criminal matters, if you agree to deal with them through ADR, you are committing an offense. And the ADR Act, by the ADR Act, you could be finding yourself in jail if you did that. Right, Ishan, you're calling from Cape Coast. Let's hear you.
Good evening, Mr. Samson.
Hi, Ishan, let's hear you.
Please, I wanted to ask a question about the mediation. My first question was that what are some of the conditions that lead parties to mediation? What are some of the conditions that lead parties to mediation? And if there is a need to apply mediation, and both parties does not conclude the agreement, what is the next step?
Okay.
And my last question is that
I suppose you are joining us a little late, but we'll see what we can repeat about that to you. Kojo, you are calling from Kaswa. Let's hear you.
Good afternoon.
Good afternoon.
Please, I heard one of the panelists said if... hello?
Go ahead.
Please, I heard one of the panelists said if an award is given, it cannot be overturned at the law court.
Here? You heard it here?
What of if I have a document present during the course of
Kojo?
the mediation?
Hello, Kojo?
I could not get it. But after the award was given to my opponent, I got the document. Hello?
First of all, I need to be careful about what you're saying. Are you saying you heard it here on this show this afternoon?
Okay, if that is not the case, let me just say yes, please.
No, you didn't hear it here. But you go ahead.
Then,
go ahead with your concern. Go ahead with your concern.
Yes, what I'm saying is if an award is given to somebody in arbitration,
yes,
the party is to submit a document, but he could not submit it in the process. Afterwards, then he get the document. Can he take the matter to court?
Okay, thank you. That will be our last call. We have Francis. Francis will be our very last call. Hello, Francis. Let's hear you. Hello, Francis. Okay, so that'll be, we end it with Kojo. All right, so there was a Shen before Kojo, and you remember what a Shen had to complain about, yes. And then Kojo too brings in the aspects of setting aside award or whatever it is. So what will you say?
Yes, the assertion that mediators were hostile, if indeed that actually happened, then it's regrettable. That is not what is expected of mediators. All mediators that practice in our courts are trained. Martin has been involved in some of this training, and we bring them up to the level where these principles we are sharing here are familiar to them. But of course, if you have over 800 mediators working across the country, then of course you are likely to find some of these bad nuts. And my worry is that even when he was asking us about it, he said, oh, I don't want to create an impression so that you get an idea as to where this is coming from. That is one harm we do ourselves as a nation. Why must we hide people who are not ready to cooperate and to help us to serve our countrymen well? And so that actually shouldn't be the case. And so anytime those issues come up, they are brought up for disciplinary action. And so I will appeal to the person who called to actually get in touch so that we know where this thing happened, so that whatever we need to do to improve upon that condition, we do so.
Okay.
Somebody also asked as to what conditions necessitate mediation.
Right.
Yes. The condition, as we have outlined here, is that there must be a dispute between the two parties, and that dispute must be amenable to ADR. If they are in dispute and they are seeking redress, and the issue at stake can be addressed by ADR, then of course these things can lead them to mediation.
All right.
Ananda, let me just quickly add with regards to what can lead parties to a mediation. In addition to what Nat just said, at the base of it is always the question of relationship. You know, I normally illustrate this with a tree, as the tree says, if you send me tumago, nisia hatabonten. Simply meaning that you don't wash your dirty linen in public.
Right.
So if this is a wife, a son, a daughter, brother-in-law, a colleague at work, a business partner, you have very, very essential relationship with this individual. You depend on them, they depend on you. Disputes and conflicts are part and parcel of our human relationship. They will definitely come up.
Right.
So when they come up, it's better we find an amicable solution to it, so we can preserve this essential relationship. In fact, people have been in dispute, and after the dispute was resolved amicably, their relationship soars. It gets to the next level. And that is what we want to encourage. The anger, the acrimony, yes, they are well-founded, we may be disappointed. But at the end of the day, look for a solution that will preserve, save that marriage, save that business, and so on and so forth. And this, again, is one of the huge advantages of ADR.
Right. On the matters that are amenable or not, I think the little explanation, we can keep it there. The question some have asked, and they asked last week, was about fees. Because everybody must get something for the service they perform. But we are talking about it as if the whole thing is free, 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 free. Is that true that it is free? Is that what it is? Yes, starting with you, Martin.
No, it's not free.
Okay.
Mediators and arbitrators work for a fee. But the fees, the interesting thing in mediation and arbitration is that, unlike the court situation where every client would pay his lawyer, in mediation and arbitration, the fees is levied and the parties share it. So in other words, they'll be paying 50% of what they should have paid. And there's always a basis for levying fees. You know, you just don't pull it from the sky. It must be reasonable. And looking at the nature of the case you are helping resolve, is it a matter involving a business transaction that is worth so much? And so on and so forth. So, and it is negotiable. No, you mentioned the fees. If it's okay for the parties, they'll be willing and ready to pay. If it is not.
What is often said about ADR is that it is cheap when it comes to even the fees. Is that true?
Well, this was the impression given from the very beginning, because there was a lot of education to encourage people to, one, understand ADR processes, and then two, to use them.
Right.
So because of that, civil society intervention came in so much.
Right.
That, in fact, even till today, if I'm not wrong, Alex will confirm that a lot of the things they do at court-connected ADR are funded by certain international organizations.
Okay.
Because the government funding is always not enough.
But generally, it's true that it's actually cheap.
comparatively,
Right.
it is cheap comparatively because
Okay.
you're not going to spend so much time
Right.
and so much resources.
Right.
So the rates are usually reasonable.
Okay, and in Justice Dennis and Barbara Kayesu's book, they talk about the customary one. They talk about a fee or a token that has to be paid. Time is run out of us. We have run out of time. My guests have been Alex Nate, who is National ADR Coordinator, Judicial Service of Ghana. Martin Wasu is Legal ADR Practitioner and Senior Lecturer, Ghana School of Law. I'm Samson Lardy Anyenini. This has been The Law. It's your legal light. It's your help law. Thank you so very much. And thanks to our guests too for being with us this last 2 weeks. Thank you very much indeed.